Welcome, everybody, to the Loud Little Ducky. I am just going to do a live and chat with people about things that are on my mind. Let's see here. We can do. You can't really see any of that. Let's go with it. That works. All right. And we are going to share this video out to Twitter. And a lot of people may just be on replay crew, which is completely fine as well. But I had some time to do a live, which I did not think I was going to get a chance to. And so that is what I'm doing. So we are going to, I ran across this case today that was pretty funny. And so I wanted to listen to that 911 call and show the body cam footage. It is a case that is out of the UK, but it was funny. And then I'll also have a link to the entire story behind that case in the description box so that you can go actually watch the story if you're intrigued by the body cam footage and the 999 call, because it was in the UK. It's not 911, it's 999. Also have some thoughts about David Gingras and what all he's doing, because he's off the rails as usual. And then another thing I wanted to discuss was I am working on trying not to have mouth noises as much. If anybody knows a program or something I can use, that would be great. I know that shutting my mouth all the way is one thing that I'm gonna have to train myself not to do. And then some of my medicines make my mouth dry. And so I don't really know how to necessarily fix that issue completely. I'm trying to back up from my mic. I have a foam thingy on my mic. And then I guess I'm also gonna get one of those like covers that you can put between your mic, like a pop screen or whatever it's called, to see what else can help, because I don't mean to annoy anybody. All right. So I want to discuss the discipline process for the Arizona bar. So we're going to share screen and we're going to start with no, that's not what I want. Where did it go? Oh, here we go. All right. Let's see if we can make this bigger. Did that help? Okay, the frame's gotta go away. All right. Let's do that. That looks good. Okay. So as we know, our favorite attorney, David S. Gingras, is dealing with the discipline process at the Arizona State Bar. And so let's go through that process, see where we're at, what's next, and all of that, because Gingras is complaining that Snitchel Ninja has some wording wrong and just calls her names instead of, oh, like it's defamation. It's not defamation because reason and belief that she thinks that. So it's really not far from the truth, but that's why you can't sue for defamation. But he thinks that if anybody says something or makes a misstatement or jumbles some words, it's automatic defamation and they're a liar and they're evil and manipulative and psychotic. But he's not when he does those things. So the state bar's lawyer regulation department is designed to resolve most disputes informally and to formally investigate serious allegations of misconduct. Almost all disputes or concerns start with the bar's intake department. Intake serves as the intake and pre-screening function of the state bar's lawyer regulation department. Intake may be able to help if a client is having a dispute with his/her attorney, if an attorney, alternate business structure ABS, or legal paraprofessional LP is having a dispute with his or her client, or if an attorney ABS or LP is having a dispute with another attorney ABS or LP. Other more serious matters are referred for a screening investigation. So, when we go to intake, charges can be made by any person and can be submitted in writing, over the telephone, or through the state bar's website. Once a charge is received, an intake lawyer is assigned to review the charge and determine if it should be dismissed, can be resolved quickly and informally, or if it should be forwarded to litigation for further investigation. So this is where the Arizona State Bar, with my complaint, stopped. Is they had the they had the intake part, and then because they said it would be better suited maybe for California, they were going to stop it there. So it didn't get forwarded and it just stopped at the intake part. Intake lawyers will often call the complainant making the charge as well as the respondent attorney to discuss the charge and gather preliminary information. If the intake lawyer determines there is not sufficient grounds to proceed with the disciplinary charge, the intake lawyer may dismiss the charge at this point. A complainant who disagrees with that decision to dismiss has the right to appeal the intake lawyer's decision in the Chief Bar Council, who will review the decision and decide whether to uphold the dismissal or the conduct further investigation. If the intake lawyer determines there are sufficient evidentiary grounds to believe the lawyer violated its ethic rules, the intake lawyer may decide to offer diversion to the respondent attorney to resolve the charge. If the intake lawyer believes the violation is serious enough to warrant more than diversion, the intake lawyer may request a written charge from the complainant and refer the matter to the litigation department for the screening investigation. So it goes from the intake to the screening. So screening is once it goes to be investigated, and not all claims are going to be investigated. Happy Thanksgiving to you as well, Steve. So the screening then happens once the written charge has been referred to the litigation department for a screening investigation, which I'm guessing this is where Jim comes in for David Gingras, um, the bar guy, as he calls him. All right, finally got that shared to Twitter. Okay. The assigned litigation attorney forwards a copy of the charge to the respondent attorney with a request for written response. By rule, the respondent attorney may receive one extension of time up to 20 days in length by requesting such from the litigation attorney. Further extensions can only be granted by the chief bar counsel upon showing of good cause. Once the respondent's attorney's response to charge has been received, it is forwarded to the complainant. And we saw some of that with Lauren Knighty, where David had to respond. Then they sent it to Lauren, which is where Gingras compared things happening to being driving while black and being pulled over, which is ridiculous. Okay, forward to the complainant. At this time, the assigned litigation attorney reviews the charge, response, and evidence and may conduct additional investigation or obtain additional evidence as needed. The assigned litigation attorney then creates a report of investigation detailing their findings and making a recommendation as to the appropriate outcome of this matter. If he recommends for diversion or discipline, a copy of the report of investigation will be sent to respondent's attorney. If the recommendation is for dismissal, a copy of the report investigation is not sent to the responding attorney. The complainant is not provided with a copy of the report of investigation. In any event, however, both the respondent attorney and the complainant are notified of the decision to the assigned litigation attorney. If the complainant disagrees with the recommendation of dismissal, they have the right to appeal that decision to the Attorney Discipline Probable Cause Committee. Most people, thus far, if their claim has been just dismissed or whatever, at whatever level, none of us have appealed it, I don't think. There has been some that possibly had to submit new ones because more stuff that he does. Sorry, I hope that wasn't too loud either. Like I said, I'm not trying to annoy people with mouth sounds. Maybe I need to do chapstick, which I don't normally do. Keep my mouth wetter, but then that makes me swallow. I don't know how to just not make noises with my mouth. But I get it because I kind of deal with misophonia myself. Okay, so then things go to probable cause, which this is kind of where we're at with dealing with Gingras. If the litigation attorney is recommending diversion or discipline, the recommendation is submitted to the Attorney Discipline Probable Cause Committee, the ADPCC. And that is a committee of the Supreme Court of Arizona and is independent from the State Bar of Arizona. The committee meets on a monthly basis and reviews recommendations submitted by the State Bar, as well as a dismissal appeals submitted by complainants. The respondent attorney who has a matter on the calendar to be considered by ADPCC may submit a written response to the State Bar's report of investigation to have it considered by the committee. Bar counsel appears at the Attorney Discipline Probable Cause Committee meeting and makes a brief presentation of the matter to the committee. The meetings are not public, and neither respondent's attorney nor the public may attend. Okay, so those people are not allowed to be there. The ADPCC has the ability to affirm the bar's decision, to change that decision, to dismiss the matter, or to direct the state bar to conduct further investigation. If the committee affirms the bar's decision to issue an order of diversion or an order of informal discipline, an admonishment, probation, restitution, then the order becomes final, absent further objection from respondent's attorney. If the respondent attorney wishes, they may object to this order and demand formal proceedings. If this occurs, or if the bar is recommended a formal sanction, reprimand, suspension, disbarment, then the ADPCC issues an order of probable cause and directs the bar to engage in a formal disciplinary proceeding, which is what happened with Gingras. Let me try to bring. All right. All right. So I'm just going to bring up one of these orders to show. So I am going to present. All right. So we'll get that back up in just a minute to continue going where we go from here. Sorry, my dog is snoring too. Okay. Oh, gosh. What happened here? Okay. So here we have the Attorney Discipline Probable Cause Committee of the Supreme Court of Arizona reviewed this matter on September 12th, 2025. Pursuant to Rules 50 and 55 of the Arizona Rules of Supreme Court or Superior Court, I don't know, for consideration of State Bar report of investigation and recommendation. Why is that? I don't know why that can't be bigger. We're going to continue to read it. By a vote of 7-0 to 2, which the 2 there is that there were 2 committee members that did not participate in this matter. But the thing is, if they were there, I fully believe it would have been a 9-0. Also, you only need 6. But everybody that was there unanimously agreed. The committee finds probable cause exists to file a complaint against respondent in file da-da-da-da-da. And there are 6 of these. It is therefore ordered pursuant to Rule 55C and 58A Arizona Rules of the Court, authorizing the State Bar Council to prepare and file a complaint with the disciplinary clerk. Parties may not file motions for reconsideration of this order. Signed, Judge Cindy Bailey. She was the chair, Attorney Discipline Probable Cause Committee of the Supreme Court. And it was sent to Gingras. It was sent to the Attorney Discipline Probable Cause Committee of the Supreme Court of Arizona. It was sent to the Lawyer Regulation Records Manager of the State Bar of Arizona. It was sent to, of course, Gingras. And then filed. So it doesn't look like, and this was all done back in September. But of course, Gingras didn't let anybody know about any of that. Why would he? And so, yeah, 1, 2, 3, 4, 5, 6. We know that Judge Mata is probably one. Mike Maricini. We know Cat Lady Ballerini or somebody in the JFC community, which I don't know the story behind that one. So if anybody knows the story, or you don't have to put it like anywhere public, you can DM me or email me or whatever. So Mata, Maricini, JFC member. I don't know who else. There's 2 other. I don't know if one's the PS creative or what. I know it's not me, it's not Lauren, it's not Echoes. I don't believe it's Dave. So I don't. Oh, Dr. Deans, which was the doctor that claimed or came and testified on behalf of Clayton Eckert in that case. So I don't know who the 5th one is. All right, let's bring this back up. So since we know that it's going to go from there. All right. All right. So we read the probable cause. All right. Formal proceedings. Because so they're going to file the complaint. All right. Formal proceeding is or initiated by initiated by the state bar's filing of a complainant with the disciplinary clerk of the Supreme Court. So that is what was going to be happening. Now, it probably already has happened. The process is overseen by the presiding disciplinary judge and proceeds similarly to the litigation in a traditional court action. Once the complaint has been filed, the respondent attorney files an answer. A scheduling conference occurs before the presiding disciplinary judge, and the parties engage in discovery and disclosure. A settlement conference is generally held in a formal litigation matter. The parties have the ability to enter consent agreements, which is a type of settlement. Consent agreements must be approved by the presiding disciplinary judge before becoming final. If the matter does not settle, which we know Gingras is not going to settle to any of this because he never thinks he's wrong because he's the all-knowing David, it will proceed to a hearing on the merits, which is similar to a trial. So this is where like Gingras is like, oh, I'm going to get to cross-examine or depose Judge Mata. The hearing is held before a disciplinary panel consisting of the presiding disciplinary judge, a volunteer attorney, and a volunteer non-attorney member of the public. Witnesses are called and evidence is presented. The two sides make all their respective arguments. After the hearing, the disciplinary panel issues a decision regarding the outcome of the matter. And my thing is that David is going to have to address the claims against him. I don't think he's going to be able to ask about nonsense that is not in regards to her complaint. He's not gonna be like, "Oh, you were biased against Laura, right? That's why I did these things," and stuff like that. I think it's going to be in the confines of the complaint, and he doesn't get to go off on tangents of all things he wants. Alright, and then after that, because I'm pretty sure he's gonna lose that if he hasn't already. We haven't been told about it. There is an appeal process, which I'm sure he will try to do. He may not. He may just give up right then and there, because he says, he doesn't want to be an attorney in Arizona anymore, and Arizona is stupid, basically. If neither party appeals the decision of the disciplinary panel, the decision becomes final. However, either party may choose to appeal the decision to the Arizona Supreme Court. Should one of the parties appeal, the court sets a brief schedule. The parties submit briefs, and the court may or may not hold oral argument. The Supreme Court then reviews the matter de novo, which is basically as if it were new and never decided. So they take it from the beginning and may uphold the order of the disciplinary panel, modify the order, dismiss the matter, or remand the matter back to the panel for further proceeding. If the court affirms the order, modifies it, or dismisses the case, that decision is final. I feel like they're going to affirm it if he appeals. All right. Then we get to sanctions. There are many possible outcomes to a disciplinary case. A case may be dismissed, or an attorney may be ordered into a diversion program, such as taking CLE or receiving law office management assistant. Diversion is not discipline, but rather is an alternative to discipline. Lawyers may receive an order of admonition, may be placed on probation, or may be required to pay restitution. These are all considered informal sanctions. Formal sanctions, which can only be issued by the presiding disciplinary judge or the Supreme Court, consists of an order of reprimand, suspension, both short-term and long-term, and disbarment. So those would be formal sanctions, which hopefully he has. Lawyers disciplined as a result of a disciplinary proceeding are required to pay the cost of the proceedings, which vary depending on the procedural stage in which the matter is resolved. I don't think they'll see a dime from him, even if they require it. And then reinstatement. So if he wants reinstatement, or, because he's been suspended, disbarred, or had their license revoked as a result of discipline, must be reinstated prior to resuming the practice of law. If it's been 6 months or less, a short-term suspension, they may file an affidavit pursuant to the Supreme Court rule in order to apply for reinstatement, which I believe he did the last time he got suspended, several years ago. And then if he has been suspended for over 6 months, which is a long-term suspension, he must file formal application for reinstatement and participate in a formal reinstatement hearing before a disciplinary panel to show rehabilitation and fitness to practice. Yeah, good luck with that. The state bar may or may not oppose the reinstatement. Attorneys who have been disbarred may formally apply for reinstatement after a period of 5 years has passed. So if he gets disbarred, he's not going to be allowed to practice for at least 5 years. And he must go through formal reinstatement proceedings to show fitness to practice and rehabilitation. And an ABS, whose license was suspended 90 days or less, may file an affidavit, shall file written application for reinstatement and all of that. So hopefully he gets disbarred, and then at least for 5 years, probably forever, he will no longer be an attorney in Arizona. It doesn't mean he still can't practice in California. So that stinks because he just needs to walk away from the law because he has a horrible understanding of it. I was going to look at, which I forgot. Let's see. Let's see here. Let's see here. Okay, let's search what it has right now on file for him because I have found stuff from before. I've found all the files from before that are on there. All right, let's view his profile. 2008, 2009. See, it's got his biography. He does not have professional liability insurance. He is not board certified in any legal specializations. So I don't know if we'd have to look up something else, but so that is that. And then apparently he did another live. I don't watch his lives. I don't care to waste my time on that. My dang dog. Posts all his accolades and energy. Oh, he was on the news for some Valley residents see sky-high energy bills following record-breaking heat. So he spoke to ABC 15 Arizona about that. Oh, girl. All right. What's this one? Part 2 of 6. Okay. Okay, let's look at this one. So this is David Gingras's, one of his newest, I think it's his newest blog. So share screen. All right. Why does this keep doing it? All right. We have Unpacking the Bar's Bullshit, Part 2 of 6. Assholes. I guess I'm going to have to go look at 1 because I don't know where Part 1 is. And he wrote this today, or November 26th. And this is in the file called The Bar Guy. I don't know if y'all can still hear me with this, even though I'm not necessarily on the screen, but let's see here. Okay, I have got to do something about her real quick. Let me play. She's my grunty pig. Well, we will play music. While I do that, here, I'll show you. This is my grunty pig. This is my little grunty pig. Are you the grunty pig? This is a grunty pig. Yes, hers is the grunty pig. Hers is pretty girl. All right. Let's put on a thing. We'll just put on this. Loud little ducky coming through, speaking truth, unabashed, calling out the liars, debunking falsehoods with a blast. I ain't afraid to say what's real, won't ever hold back. Gonna shake the system up, turn it all off track. I see through the smoke, the mirrors in the disguise, expose their hidden agenda. No more room for their lies. The truth is my weapon, I won't let it be concealed. I'm the voice for the voiceless, no longer gonna yield. In a world full of deception, I'm here to set it straight, bringing justice to the forefront. Won't accept their twisted fate. They may try to silence me, but my voice will still prevail. A sparking revolution, it's a truth-telling tale. Okay, I'm back. She's going to be done snoring in the video, but she can go snore somewhere else. Okay, let's bring this back up again. Okay. He says, update. I turned comments on, but will turn them off if people get too salty. Because he can't take the heat. Can you taste that turkey? I'm not eating anything you're serving. Even if you are a good cook, I don't trust it. You'd probably try to poison us. All our differences aside, I want to extend my warmest wishes for everyone to have a nice, relaxing, festive Thanksgiving. It's one of my favorite days of the year, and I'm looking forward to enjoying every moment of it. Good. It's actually my favorite holiday as well. Food, family, you got football. Amazing day. I like my family. I'm sorry for anybody who has to deal with their in-laws or other family members they don't like. Try to bite your tongue. We don't want any family drama where anybody ends up in jail. And do not drink and drive. But before I do, I wanted to take a stab at addressing the second bullshit claim the Arizona bar guy is pursuing against me. This involves a matter designated as file 243080 on the list below. This is the second specific thing where Jim Lee is the complainant. Okay, so Jim Lee is number 5, I'm guessing. And we don't even know Jim Lee. But last week, I made a video talking about the last item on the list below, file 251230, which was another allegation Jim Lee came up with on his own, accusing me of violating court order relating to a motion to compel. As I explained in that video, Jim Lee's allegations were 100% factually false, not even 1% true. Of course, it is possible he realized this and removed that claim from the complaint he plans to file. I have no idea because I haven't seen the complaint yet, but guess next week we'll finally get to see it. Oh, good. Next week we'll get to. So thank you for that update because I was wondering when we would. Okay. Does this 28? So this one I pulled up was for 2819. Okay, so the complaint I read as the sample, because all 6 of them are different, is Mike Maricini. Somebody is an internet person that he blogged about. I'm sorry, I put that up on the screen. Who attended the trial. Then there's Dr. Samantha Deans and Faye just to see a Lind, opposing parties testifying expert medical witness. And then the next one would be State Bar of Arizona Judicial Referral, Maricopa County Superior Court Judge Julie Mata, judge presiding over the case in which respondent represented a family law client. Mike Maricini, an anticipated witness for opposing party. And then we've got this one, which is from the State Bar of Arizona. And another one that is from the State Bar of Arizona. Which we don't even have those listed. So 2483, we've got that one, which is Mata's. 2819, which is Maricini's. Okay, 1230 is a State Bar. Samantha Deans is 1826. Okay. $16.19. 1692. Okay. And then 3080. Okay. Yeah, I guess we do. 12. Okay. Yep, we have all those. Okay. So 2 of them are apparently from Bar Guy. Okay. So what exactly was file number 3080 about? Thankfully, this part of the case has nothing to do with any ER 1.6 privileged material, so I'm happy to show you the complete allegations in their entirety In fact, the entire complaint is only 4 paragraphs, as shown below. The whole thing is based on an email, which is a matter of public record. Great. And it is on Court Listener. So, allegation of misconduct addressed in the file is about the public warning, which is addressed above. On November 21st, 2024, respondent sent an email to Laura Owens and copyright at Reddit, in which he identified himself as a lawyer in Phoenix, Arizona, representing Owens in her case against Clayton Echard. That email message stated in part, Clayton Echard's fans, generally speaking, are total effing psychotic a-holes. Clayton's fans, being total effing a-holes that they are, have come up with a new plan. Italics and original. In the email, respondent complained that someone had infringed on his copyrighted work, video recordings on youtube.com. On December 4th, 2024, respondent filed a request for subpoenas to identify infringers pursuant to 17 USC 512 and supporting declaration. Respondent included a copy of his November 21st, 2024 email message as Exhibit A to that request for subpoenas. In response to the concern about his email to Owens and Reddit, respondent generally stated that his comments are protected by the First Amendment, including the characterization of others as an a-hole. He cited various cases for the proposition that a non-lawyer may refer to others as an a-hole. None of those cases, however, were lawyer regulation discipline cases. Conclusion, respondent violated 41B7 Arizona rules of whatever by engaging in substantial or repeated instances of unprofessional conduct. Allegations of misconduct addressed, and that's a different one. So he says that bar guy Jim Lee, because I used the word a-hole in a private email sent to Reddit, this is violated. Well, yeah, because you were acting as an attorney when you wrote this email. You weren't doing it as a Reddit user. You were doing it in your capacity as an attorney to try to get information for Laura to try to sue this person, which was ridiculous. You were acting as an attorney, whether you realize it or not. You just were. And it doesn't matter if it was a private email. You were acting as an attorney. To avoid engaging in unprofessional conduct and to advance no fact prejudicial to the honor or reputation of a party or a witness unless required by the duties to a client or the tribunal. He says, okay, notice anything wrong? First, anonymous JFC people I was referring to are not a party or a witness to any case I was working on. Second, the email I sent Reddit was not sent on behalf of my client. I sent the email for myself. I was unhappy with someone taking my copyrighted protected material and using it to create derivative works. Fair use, sir. Fair use. Why does this matter? Because Arizona Supreme Court has only authority to regulate the practice of law. All right, what did this say up here? You identified yourself as a lawyer representing somebody in this case. Talked about the guy in the case. And there are ellipses, so it doesn't have the rest of it. Let's see. Does it have the whole thing? Is that what this does? Okay, let's bring this up. Let's take this shit down. Okay. Okay, let's bring this up. Is this what it is? I think this is it. Okay, so we're not having to do ellipses because Bruce doesn't like that stuff. My name is David Gingras. I'm a lawyer in Phoenix, Arizona, and I'm sending you this notification claimed infringement per this. Sounds like lawyer talk to me. I'm currently representing a woman named Owens. So you talk about who you're representing. Laura claims she became pregnant after hooking up with this person, claims she faked it. Clayton's fans have posted tons of YouTube videos about this case, and by tons, I mean thousands of videos. As a part of my effort to respond to Clayton's fans, I have started posting my own videos talking about this. Clayton's fans are generally speaking are total effing psychotic a-holes. As part of this, Clayton's fans, the ones with YouTube channels, have recently started copying my videos. No, we're not copying your videos. If we were posting them on our channel with no commentary, that would be copying them and acting like they were ours. But we don't do that because we definitely don't want to claim anything. We just want to comment on your dumbass. They're doing this for stated purpose of ensuring that I do not get views on my channel. No, we're not. Below is a screenshot of a tweet where one of Clayton's fans brags about specific issues, asking people to go watch my video on someone else's channel. Well, we've debunked that. I've come up with a new plan. Rather than streaming my videos on YouTube, they are writing detailed descriptions of my videos and posting those descriptions on Reddit. I don't need to explain this to you, but creating detailed written descriptions of my videos for the purpose of whatever he says is not fair use. This is creating a derivative work and it is a violation. No, it's not. Those are the Reddit things. Okay. Those are some YouTube videos. Contact. I have good faith belief the material manner is not authorized by a copyright owner. Information belief. And you wrote this under the penalty of perjury. Megan asked, rather than see, okay, so this was the justice for Clayton person. Lauren didn't ask that. Somebody else did. And it wasn't even there. It's not justice for Clayton's video. Like you wrote this in your capacity as an attorney. So yeah, you are declaration. Yeah. Sorry, David, but you wrote this as an attorney. So you saying that this is just you writing, as a non-lawyer, that's a lie. Because if you were just writing it as an average citizen, you wouldn't have been putting all that nonsense in there. Because you would have written it like I would have written it as a nobody, basically. So once again, you are speaking bullshit. So much bullshit. And he says the bar's bullshit. No, it's Gingras's bullshit. I didn't send it on behalf of my client. No, but you sent it as that. Sending an email on your own behalf is not practicing law, even when you're asserting your own legal rights. Yes, I could have been like, according to this and this and this, I believe this is wrong. But because you were like, this is a case, these are the parties, they are talking about this case, and I was talking about this case. So I think it's in his capacity as a lawyer. We'll see if the bar people or the discipline committee or Arizona Supreme Court, whoever agrees with me. Look, I'm sure Jim for Lee, for all his other faults, understands that Arizona, the practice of law, has a very clear and specific definition. Don't take my word for it. Let's just quote the definition. Means providing legal advice or services to or for by another. Preparing or expressing legal opinions to or for another person or entity. Representing a person, okay? Preparing a document in any medium on behalf of a specific person or entity filing in a court, negotiating legal rights or responsibilities on behalf of a specific person, preparing a document, okay? Um, I don't know that it is, but I don't know if it's, I think it's in your role as an attorney. If you're using an I'm an attorney, you are under the bar's jurisdiction. If you go into the grocery store and you get into an argument with the cashier and you don't mention anything about you being an attorney, or you tell the cashier to go screw herself, that's not you practicing law. But it could probably be similar to the fact that, like, if you work for a company and you go out there and act unbecoming of somebody that they want to work for that company. Mm, um, let's see here. I don't know why the formatting is being dumb here. But let's say you work for a company. Lately, I'm sure a lot of people have seen people acting crazy, like on TikTok or something, or saying horrible things on Twitter or whatever it is. We've even seen people act horrible at like a sporting event. And then it gets back to the company. And then that company, because they are associated with it, acts a certain way and they fire them because they do not want anybody associated with their company that acts a certain way. So to me, the bar, Arizona bar, is kind of like that with Gingras. The Arizona bar can decide that if you are being a lawyer and doing things that are unbecoming of a lawyer of the Arizona State Bar, they can decide they do not want you to be associated with them anymore, just like a company can decide they do not want to associate with you anymore. I think that's also true when um he now I lost my train of thought. Um okay, and he talks about the Arizona like anti-slap law and stuff like that. Let's mm, let's see. You finally get to see Mr. Lee's complaint next week. He said I could immediately move to dismiss it, but he won't. Instead, I'm going to issue subpoenas to get info from the judges and others to defend the part of the charge against me. So he is going to defend it. He says he did not engage in the practice of law. You know, calling someone an a-hole is not nice, but it's protected by the First Amendment. But that's the thing that I was gonna say is, like, with the First Amendment even, you have the right to say all those things. These people that get fired from these companies, they have the right to act a fool and be horrible people, but that company can still fire you and say, "We don't like your speech." That's not infringing on your First Amendment rights. The Arizona bar to me is similar, where him getting disbarred for his behavior is not infringing on his First Amendment rights because he does have the right to say it. And he's not going to go to jail for it. There's nothing criminal that's going to happen to him for saying things that he says. But the Arizona bar has the right to say, if you are going to act this way, you are not going to be associated with us. And it has nothing to do with your First Amendment rights because they're not throwing you in jail for it. They're disciplining you for unbecoming conduct of an attorney. I'm thinking he's missing stuff when it comes to practicing of law. Ah, no, I don't want the unauthorized. What's this one? I do not want to open up a PDF. Hmm. That's not what I wanted. Why is it talking about unauthorized practice of law? What is this one? It's the same dang thing. Let's see. Misappropriation of, well, that's not good. Misappropriation of trusts. Let's see. Embezzlement, obviously. That one's a no-no. Fraud, dishonesty, lying to a court or forging documents, causing significant harm to your client, not practicing while you're suspended or disbarred. Um, I don't know, but I think unbecoming conduct of an attorney in your capacity as an attorney and throwing around the "I'm a lawyer" all the time. "I've been a lawyer for over 20 years." Nobody gives a shit. So, that is that one. He wants everybody to enjoy your holiday. And he says, "0 chances of any more blogs/videos from me, at least until after pumpkin pie. No, please take the day off. Please, please take the day off." All right. So that was 2 through 6. Okay, that was the second one. I found the first one, Unpacking the Bar's Bullshit, Part 1. All right, so it's actually handling 2 people here. "'Twas the Monday before Thanksgiving, and here I am seething. Well, not really. Mildly annoyed is more like it. It's Monday. I'm always grumpy on Mondays. Sir, you're grumpy every day of the week. Every day of the week, you are grumpy. Your video seems like you were a bit moody and seething." But he says, "Let's get to the point. The Arizona bar guy is still exercising his right to remain silent, a right I don't agree he has." Okay. "In fact, let me be clear about something. I previously suggested I could sue the bar." Oop. "Under a legal doctrine called Ex parte Young. A friendly troll named Bobby has tried to challenge my position because Bobby thinks a doctrine called younger abstinence would apply." Sir, Bobby is not real. Okay. All right. You're still mad at Bobby. We went through that on the last Gingras video. "Since my thoughts are mainly focused or mostly focused on turkey this week, I don't want to waste time debating Bobby, except to say, among other problems with his analysis, Bobby is skipping over the fact that federal law allows for affirmative claims for relief." Okay, well, good for you. Bobby the robot does not give a shit. His First Amendment, blah, blah, blah. Nobody cares about his First Amendment. Sir, what the hell are you wearing here? No. As a Texan, no. Bar guy's bullshit allegation that I violated the motion to compel disclosure order by failing to give documents to Woodnick and by never informing attorney Woodnick that documents did not exist. If you haven't seen that, here it is. You can go watch that if you want. Today, I want to cover a totally different thing. And this is something that the JFC crazies raised very early on. The idea I violated a court order. So this was one of the things that I wanted to discuss as well. He did violate a court order by releasing exhibits. The thing is, the stuff was supposed to be shared between the parties and between the parties only. Any exhibits. Let's see. So the alleged violation on September 14th, prior to respondents' involvement in the case, Owens filed pro se expedited motion to seal court record, asking the court to seal the entire record in both the paternity case and the OOP case, as well as records that may be filed thereafter. Yeah, she didn't want anybody talking about it online. She blamed it all on like the Gregs and the Mikes and the Claytons. They were the ones releasing it to the public. But it was public record. And then Gingras got on the case and he shared it all publicly, exhibits and all. Because you will notice that we didn't really have a lot of things when it came to Woodnick. She wanted it sealed. We all saw that order. Way back on my birthday. Well, I bet that was a good birthday and maybe your last decent birthday because Laura entered your life then. All right. He says specifically, Woodnick argued Mata could not issue an order preventing the parties from sharing information publicly because that would constitute an impermissible prior restraint on speech. He was actually partially wrong about that, but whatever. Woodnick also argued this new motion was BS because it asked for the same relief Laura requested in September, which Mata denied in October. He also argued it was premature because the court can't order something to be confidential before the material existed. Woodnick also argued that it didn't matter if Laura was embarrassed. Well, it doesn't. Embarrassment is not a reason to seal a court record. I don't know why he has any problem with Woodnick's arguments here. Now we know on February 15, 2024, but not filed until February 21st. Doesn't matter. These were filed before you got on the case and you should have known about them. Mata issued an order denying Laura's motion for confidentiality/protective order. This was not a partial denial. Mata did not say, I'm denying in part, but also granting in part. Nope, she just denied the whole thing in its entirety, as always with zero explanation. She doesn't have to give an explanation. She just doesn't. And so she says, February 15th, order denying second motion for confidentiality. So from September to February, Laura asked Mata to grant confidentiality twice, and Woodnick argued, hell no. The court can't seal anything, and it would be illegal for Mata to issue prior restraint on speech by telling the parties they were not allowed to share information before the information was actually known. Mata agreed with Woodnick, and thus twice Mata refused to allow anything to be sealed confidential. Sure seems like the ship had sailed, right? Well, not so fast. Because we know there was a status conference held on the 21st, more than a month before I was hired. Doesn't matter. You should have still known about the rules when you came aboard. That is your job to know. Corey Keith raised the issue of confidentiality for the third time by asking Mata to reconsider her two prior orders denying confidentiality. Mata denied the request, making this the third time she ruled on the same way on the issue. So it says, counsel for petitioner presents to the court these outlining explicit concerns is further ordered denying counsel's motion for oral motion to reconsider regarding the ruling concerning the motion. But let the record further reflect that no party shall disclose outside of themselves any medical or other documentation, exhibits, medical records, etc., disclosed between the parties. Like if there was a sonogram that Laura submitted to the court, it was to be only shared between her and her attorney and Clayton and his attorneys. It was not to be shared with the public because she claimed all this publicity that she originally wanted was not good for her. And she hated that that information was getting out. Her medical stuff was getting out. She hated that. She didn't want that. But she didn't care that her attorney shared it out. And this is where he gets into things. So and now he says, oh, Woodnick argued successfully that the order would be unconstitutional, illegal, and premature. But I guess talking out of both sides in out of your mouth isn't a problem for JFC. We also state we are not attorneys. So we don't know. But it was in an order. So we are to assume that because it's in an order, it means you cannot do it. But she wasn't sealing the record. She's not sealing the motions. But the things that go with the motions, she was saying those couldn't be shared publicly by one another. It was to be kept between the parties. What happened next is I appeared on the case in March and went bonkers trying to catch up with the mess I stepped into. Well, you should have known what you were walking into. Nobody wanted to speak to him. No, of course not. She had committed fraud in the case. The motion included tons of medical or other documentation disclosed between the parties, including excerpts from Laura's deposition discussing medical issues and exhibits showing Laura's medical records and correspondence I sent to Woodnick, among other things. Woodnick filed this pleading and exhibits unsealed. Yeah, maybe because you were doing it. I don't know. Mm-hmm. So maybe Woodnick did. Maybe Woodnick broke the motion too. Or it was a motion and he was putting the motion in, the motion was public, but he wasn't sharing other things that were shared between them. Also, okay, I think I can explain a way for this. So, Woodnick didn't publicly share documents. Like, he wasn't putting them out on Twitter, he wasn't emailing them to them, he wasn't putting them out to the public. So he wasn't sharing things like to the ether. He filed them in court. And the court made them public. So things weren't getting just put out there willy-nilly, I guess. Because that's the only thing I can think of is Gingras did it because he was sharing it just directly online. Whereas Woodnick just filed stuff in court. And then it was just public on the docket. So it wasn't the parties directly sharing it. And maybe Gingras would have been okay had he had not just been publicly sharing it. If he would have just filed it in court and we got it off the docket like we had to do for the Maricini case. And like we have to do for other cases. That might be where he's in violation of sharing it publicly. Because it can get filed on the docket, and if stuff needs to be taken out, they should do it. But it doesn't look like they really redacted things when it came to the Arizona courts. But that's not them publicly sharing information where Gingras shared it. That makes sense. By Gingras putting it on Twitter and on his law website and was like, hey, everybody come look at this. That's where he was breaking it. Because he is acting as Laura. So when he does things that have to do with Laura, he is basically acting as her on her behalf. this stuff is being done. Let's see. Of course, I supported my motion with various exhibits. He believes Mata's February 21st order denying Laura's request. Oh, I'm not sharing this. I've just been reading this and not sharing it. Okay, let's put that up. For confidentiality actually included a requirement for all pleadings to be filed under seal if they contained medical records or other documentation exchanged between the parties. Dr. Dean's report kind of arguably qualifies as other documentation. So according to the Arizona bar guy, I should have filed that report under seal. And my failure to do so warrants extreme punishment. Does he have... Yeah, Woodnick didn't file them sealed either. Okay. If that is what, in fact, Jim is saying, allows parties to designate relevant discoverable information. Da, 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 da. Proposed order explicitly stated that expert was deemed confidential, but the party designated document as confidential could disclose it to any other person or entity that designated party agreed to in writing. The proposed order also said that confidential materials could only be used for the purposes of preparing for, conducting, participating in the conduct of prosecuting, defendant, attorney proceeding, not orally moved, denied the motion. Okay, that's just the order. What is this one? Owens and her previous counsel. Respondent informed bar counsel that he believed his message to Eckerd's counsel on the 4th was clear. He did not read Judge Mata's February 21st, 2024 order as prohibiting Owens from sharing her own medical records. Oh, that's his responses. Okay, during the hearing. That's because they didn't have permission to post Dr. Dean's report. Is that a response? Let's see. Notice of appearance. There's counsel. First one where the no court order that would stop Laura from publishing her own. Yes, I'm aware there's a minute entry order. Previously was not. What is this? Did he write this up? I'm guessing he wrote that up, which is not what I want. I want to see if that is actually what Jim is saying, is that because he didn't file it under seal, that that's how he violated, which I don't think that's how he violated. So if that's what Jim is saying, I agree that that's not the reason it should be. Um, on the contrary, even if I did violate an order, which I didn't, the bar guy will have to show a consistent practice of pursuing similar legal actions against similar situated persons who did not lawfully exercise. Yeah, because if the under seal thing, Woodnick would be in trouble too. And I don't think it's not the fact that it's just publicly sharing it, and you publicly shared it. There was also a thing in here. I don't know if it was this one or a different one where he was like, Laura thought that it was Laura thought that it was a that only Clayton couldn't share things, but she could. Um, that's not how things work. If Clayton has to do it, you have to do it. You have to do it, Clayton has to do it. It's not a one-way thing. It's not protect one party and not the other. What's good for the goose, good for the gander. And if she didn't understand that, that would be her attorney's job to explain it. At the time, that would have been Corey Keith's job. Even if he would have told her about this, which he got off the case very shortly after. So Gingras should be able to explain this to her. But Gingras didn't even know about it to explain it to her. So that is shitty lawyering. That's why she has an attorney to keep her informed. So somebody should have told her what this means. And I doubt if they told her that this means, well, I mean, they might have said this means that he can't share anything about you. Clayton can't. But they should have said that also means that we can't share anything about him either. That's what a good lawyer would say and explain to her. But I don't know if any of that was done. But Laura saying, well, she didn't understand, that's the attorney's fault. And she had two during that time period that could have explained it to her. Okay. All right. Lastly, I want to show y'all this thing. And because I thought it was funny, I watched a true crime episode from somebody that I like. She's who I get a lot of like across the pond true crime stories because we have a lot of people that cover US cases. I've done, I want to do more, but I have not been able to do migrating the US true crime. But this one focuses a lot on across the pond stuff. And it is Eleanor Neal. That's what that's her name, and that's what her channel used to be called. But now her channel is called Outlaw. And mm, What is the... All right, let me show you, because I want to show you what the video looks like so that you know which one I'm talking about. Okay. All right, we're going to add this to the stage. So the Bubble and Squeak murder. A murder that shocked the British countryside. And it's about Penelope Jackson. And so that is thing. Like I said, I will put the link to that video in the description box. But now I want to show you. I'll close all these stupid Gingras tabs. Okay. All right. We're going to listen to this 999 call. So Penny Jackson calls 911 because she has murdered her husband at the time. And it is so freaking funny. So we're going to remove this. Present. Because it just made me giggle. Because nobody does this. But she was just done. And her accent, I think, probably makes it funnier for me too. Because it's so like proper. All right. Here we go.
And are you with him now?
Well, I might just go and stab him again, but...
Alright, do not stab him again.
Why? Why?
Okay, so just listen to my voice. Okay?
Yes.
Stay on the line with me.
I am competent.
Okay, are you with the patient now?
Well, I'm in the lounge and he's in the kitchen bleeding to death with any luck.
Alright, so just stay on the line with me.
Look, this is not... You're not paid enough to do with this. It's not fair.
Okay, well, ultimately, madam, I'm listening to your voice, and you're the help I have available, so we need to help him, okay?
No, I'm not.
Can y'all hear that? Because it's just silent. When it's playing, can y'all hear it? Because I can't hear it through my computer if I'm on StreamYard. Well, I may have to. Let's remove this and let's go. I'll just go to Eleanor's video. Oh. Because I don't want to play her part of it. Because I want you to actually go to Okay. We're going to add this one because this is part of the video, but I'm not going to play you Eleanor's video. I just want to play you the 999 call because it just made me giggle so bad. Okay. Let's see if this one works now. Closed captioning.
And that she'd fail at this too. Well, Penny decided that she would prove him wrong. She proceeded to stab him twice more in the abdomen. The 999 operator heard him scream in agony, and then Penny grabbed the phone and took over the 999.
Do not stab him again.
Why?
Okay, so just
At that, he goaded her and he dared her, saying, "You won't do it again. You won't finish the job," and that she'd fail at this too. Well, Penny decided that she would prove him wrong. She proceeded to stab him twice more in the abdomen. The 999 operator heard him scream in agony, and then Penny grabbed the phone and took over the 999.
do not stab him again.
Why?
Okay, so just listen to my voice. Okay?
Yes.
Stay on the line with me.
I am complimented.
Okay, are you with the patient now?
Well, I'm in the lounge and feeling the kitchen bleeding to death with any luck.
All right, so just stay on the line with me.
Look, this is not, you're not paid enough to do with this. It's not fair.
Okay, well, ultimately, madam, I'm listening to your voice and you're the help I have available, so we need to help him, okay?
No, I'm not.
All right, madam,
I don't.
how many times have you stabbed him?
I did the once,
You did the once?
and then he said I wouldn't do it again, so I did it twice more.
So, okay. So in total, how many times?
3 times.
3 times, okay.
Once I thought I'd get his heart, well, he hasn't got one, and then twice in the abdomen, so...
The operator had asked Penny to help stop the bleeding, but she refused. She damn well
Okay, so the 999 operator has to tell this lady, do not stab him again. And she's like, why not? So she stabs him. And then he said, you won't stab me again. And she was like, basically, you want to bet? She stabbed him 2 more times. She said she was aiming for his heart, but he doesn't have one. So he's just like, do not stab him again. And I'm like, how many times does that get said on a 999 call or 911 call? It was just crazy to me. And then let me get to the body cam footage because let's put this back up. Okay. Let's add this back to the stage. So now this is the body camera. The police have shown up now, okay?
I'll say anything, but it may harm your defence if you do not mention one question, anything you later rely on in court, anything you do say may be given in evidence.
Yeah. Could I get my coat? Just bear with me 2 seconds. In there. I admit it all.
All right.
Just get them. All right, I want to go in. All right.
No,
So,
he's on the kitchen floor.
can someone just stay with Devon while I go in?
There's nothing nasty, and I'm certainly not. My coat's in the.
Yeah, just
Ow,
wait
it's
2
a bit
seconds.
hot.
All right, you okay? You all right?
With any luck, you'll be too late.
All right.
She's like, with any luck, you'll be too late to save him. She's more worried about her coat. She's cold. She wants her coat, and she hopes that they are too late to save him from the stabbing.
Well, I'm called Penny, but Penelope Jackson. Can I get my coat?
We'll get you
Right, get the ambulance in pronto. We need CPR.
No, please don't.
Yeah, we need the
I should
ambulance
have
in.
stabbed him a bit more.
We've got CPR being done at the moment.
Come on.
Ma'am, you're on body cam footage. What do you mean? You should have stabbed him a bit more. And they're like, we need to do CPR. And she's like, no, don't do that. Don't give CPR. Oh my God.
You come with me, mate.
I stabbed him once. Because he's a...
I'm going to send them all.
He's an aggressive bully and nasty, and I've had enough. And when he said you wouldn't do it, I did it twice more.
What colour's your
Go
coat?
in the front,
Yeah.
grey wardrobe.
Okay. It might be a while, all right, but I'll try and get. There's obviously a lot going
She
on.
hates this man.
Okay.
She's had enough. She's fed up.
Penelope, my advice is don't talk about it now. Okay.
No, I have no intention of not agreeing to what I've done.
Okay.
I know what I've done.
All right.
And I know why I've done it. And if I haven't done it properly, I'm really annoyed.
All right, Penny.
What? If I haven't done it properly, I'm really annoyed. She wanted to make sure she did a good job on murdering this man. Ma'am. But she is like, I know what I've done. I am going to agree that I have done this. I will take the consequences. So in her mind, jail or whatever happens to her cannot be any worse than living with this man in her mind. Does she have the right to kill this man? No. No, she does not. You do not get to just do this. Even if you don't like the person, unless it's self-defense and you're in imminent harm. But she had just had enough. And if you go and watch the video, you will find out the whole story of what all leads up to this. But just seeing the body cam footage and then the call for emergency services had me, I was dying. I was like, what is this lady talking about? So it was just funny to me. As I said, it's on Outlaw. So that'll give you something to watch tomorrow or maybe after Thanksgiving to watch. But that is going to be it for me tonight. I think that was pretty much what I wanted to cover. I hope that everybody has an amazing Thanksgiving. Like I said, do not drink and drive. Get some naps in from the turkey because it makes you sleepy. All that good stuff. But I will see you guys later.